to try and keep Trump off the ballot. Representative Jamie Raskin, Democrat Maryland, we think? Not sure. Maybe not. Congress will have to try and act, said Representative Jamie Raskin, Democrat Maryland, the ranking member of the House Oversight Committee, in a comment to creepy deep state mouthpiece Axios, which swears the border is extra secure. Raskin, a former member of the January 6th Select Committee, said he is already crafting the bill, telling Axios, "I'm working on it," today. Raskin pointed to legislation he introduced with Representative Debbie Wasserman Schultz, Democrat Florida, in 2022, creating a pathway for the Justice Department to sue to keep candidates off the ballot under the 14th Amendment. "We are going to revise it in light of the Supreme Court's decision," Raskin said. Axios. "I don't have a lot of hope that Speaker Mike Johnson will allow us to bring enforcement legislation to the floor, but we have to try and do it," said Raskin, who said he'll beseech Republicans to join the bill. Very democratic, Jamie. Asterisk. Update. 1320 ET. Former President Trump has responded to the Supreme Court's ruling keeping him on the ballot in Colorado.
I am working with a number of my colleagues, including Debbie Wasserman Schultz and Eric Swalwell, to revive legislation that we had to set up a process by which we could determine that someone who committed insurrection is disqualified by Section 3 of the 14th Amendment. And the House of Representatives already impeached Donald Trump for participating in insurrection by inciting it. So the House has already pronounced upon that. And
responded to the Supreme Court's ruling keeping him on the ballot in Colorado and therefore everywhere else. According to Trump, the decision was very well crafted and will go a long way toward bringing our country together. Trump also slammed Biden for weaponizing prosecutors against him.
It's a very important decision. We're very well crafted, and I think it will go a long way toward bringing our country together, which our country needs. And they worked long, they worked hard, and frankly, they worked very quickly on something that will be spoken about 100 years from now and 200 years from now. Extremely important. Essentially, you cannot take somebody out of a race because an opponent would like to have it that way. And it has nothing to do with the fact that it's the leading candidate, whether it was the leading candidate or a candidate that was well down on the totem pole. You cannot take somebody out of a race. The voters can take the person out of the race very quickly, but a court shouldn't be doing that, and the Supreme Court saw that very well. And I really do believe that will be a unifying factor, because while most states were thrilled to have me, there were some that didn't, and they didn't want that for political reasons. They didn't want that because of poll numbers, because the poll numbers are very good. We're beating President Biden in almost every poll. New York Times came out yesterday with a very big poll for us. So they didn't like that, and you can't do that. You can't do what they tried to do. And hopefully Colorado, as an example, will unify. I know there's tremendous support. They brought our support up very strong in Colorado, because people in Colorado thought that was a terrible thing that they did. And while we're on the subject, and another thing that will be coming up very soon will be immunity for a president, and not immunity for me, but for any president. If a president doesn't have full immunity, you really don't have a president, because nobody that is serving in that office will have the courage to make in many cases, what would be the right decision, or it could be the wrong decision. It could be, in some cases, the wrong decision, but they have to make decisions, and they have to make them free of all terror that can be rained upon them when they leave office or even before they leave office. And some decisions are very tough. I can tell you that as a president, that some decisions to make are very tough. I took out ISIS, and I took out some very big people from the standpoint of a different part of the world. Two of the leading terrorists, probably the two leading terrorists ever that we've ever seen in this world. And those are big decisions. I don't want to be prosecuted for it. Another president wouldn't want to be prosecuted for it. It had a tremendously positive impact. It stopped everything cold. And sometimes you have to make, they were tough decisions. Sometimes you have to make decisions like that. When you make a decision, you don't want to have your opposing party or opponent or even somebody that just thinks you're wrong bring a criminal suit against you or any kind of a suit when you leave office. I have that right now at a level that nobody's ever seen before. I have rogue prosecutors and I have rogue judges. I have judges that are out of control. And it's a very unfair thing for me, but serving perhaps as a sample to others of what should not be happening when you make good decisions. And in my case, the economy was great. We didn't go into any wars. We totally defeated ISIS. We provided the largest tax cuts in history. We provided the largest regulation cuts in history. But think of it, no wars. We beat ISIS 100% of the caliphate. And there were no wars. We did a job that was great, but maybe I wouldn't have done that. The caliphate, defeating them, was very powerful. It was going to take 4 years. It took me 4 months.
Him, President Biden. Fight your fight yourself. Don't use prosecutors and judges to go after your opponent. Our country is much bigger than that, Trump said, speaking from Mar-a-Lago. More. Asterisk, asterisk, asterisk. The U.S. Supreme Court has ruled in a unanimous decision that former President Donald Trump will be allowed to remain on primary and general ballots in the 2024 U.S. election, after several states removed the former president under the 14th Amendment. The decision comes after several states, kicked off by the Colorado Supreme Court, ruled that Trump was disqualified from appearing on ballots, citing an interpretation of the U.S. Constitution's 14th Amendment provision, which stipulates that candidates who engaged in an insurrection or rebellion against the United States, which Trump has not been charged with or convicted of, should be prevented from holding office. Maine's Democratic Secretary of State made a similar decision days later, and a judge in Illinois recently issued a similar ruling to prevent his appearance on ballots, according to the Epoch Times. This is the first time in U.S. history that the U.S. Supreme Court has considered Section 3 of the 14th Amendment. The decision comes after a Sunday announcement that the court would come to a decision today. And of course, the left is now trying to discredit the Supreme Court despite the fact that this was a unanimous decision. CNN isn't taking it so well. Nor is Colorado's Secretary of State. As the Epoch Times notes further, lawyers for the former president asked the 9 justices to...
My larger reaction is disappointment. I do believe that states should be able, under our Constitution, to bar oath-breaking insurrectionists. And ultimately, this decision leaves open the door for Congress to act, to pass authorizing legislation. But we know that Congress is a nearly non-functioning body. So ultimately, it will be up to the American voters to save our democracy in November.
Lawyers for the former president asked the 9 justices to reverse the Colorado court decision because only Congress can make a determination as who can become president. The Colorado court's decision was the first time in the history of the United States that the judiciary has prevented voters from casting ballots for the leading major party presidential candidate, his lawyers said, concluding that it is not and cannot be correct. After the ruling, President Trump wrote on social media that he is not an insurrectionist, adding that President Joe Biden is one. He also noted that he told supporters to protest peacefully and patriotically during a rally on January 6, 2021. Before protesters and rioters entered the U.S. Capitol during the certification of electoral votes for the 2020 election, which forms the basis of the insurrection accusations against him. Justices for the Colorado Supreme Court had argued that they believed President Trump engaged in an insurrection because of his activity before and on January 6, 2021, during the breach of the U.S. Capitol building. The former president, however, was never charged or convicted of insurrection. He was charged by a federal special counsel in connection with the 2020 election, but not for insurrection, rebellion, or related charges. President Trump asks us to hold that Section 3 disqualifies every oath-breaking insurrectionist except the most powerful one, and that it bars oath-breakers from virtually every office, both state and federal, except the highest one in the land. The majority for the Colorado Supreme Court wrote in its 4-3 ruling. Both results are inconsistent with the plain language and history of Section 3. Oral arguments. During oral arguments in front of the justices in early February, at least 6 of the justices, including Chief Justice John Roberts, who was nominated by President George W. Bush, appeared to be at least skeptical of some of the claims made by the lawyer representing several Colorado voters who brought the lawsuit against the Republican frontrunner. It'll come down to just a handful of states that are going to decide the presidential election, Chief Justice Roberts said, referring to the potential effect of the Colorado court's ruling. That's a pretty daunting consequence. Justice Clarence Thomas asked the lawyer, Jason Murray, why there weren't many examples of individual states disqualifying candidates under the 14th Amendment after the Civil War. There were a plethora of Confederates still around. There were any number of people who would continue to either run for state offices or national offices, so it would seem. That would suggest there would at least be a few examples of national candidates being disqualified, Justice Thomas, a Bush appointee, said. Justice Elena Kagan, considered a member of the court's liberal wing, asked the attorney why one state would have power to determine which candidates should be on the ballot for a nationwide election. Why should a single state have the ability to make this determination not only for their own citizens, but also for the nation? She asked the attorney, adding the move would be quite extraordinary. 234, 3053, 403. More political stories on Zero Hedge. Why is Congress nuking Northeast gasoline reserve as part of bill to avert shutdown? Chaos at Georgia Six Flags as violent mob invades, ends in shootout with police. Atlas Shrugged comes to life in California. Never miss the news that matters most. Zero Hedge directly to your inbox. Receive a daily recap featuring a curated list of must-read stories. Show comments. Discrimination notice. Privacy policy. Disclosure. Disclaimer. Advertise with Zero Hedge. Copyright 2009-2024 zerohedge.com/ABC Media, Ltd.